relating to how we ameliorate the conditions of those who have been sidelined for centuries, who have been humiliated for centuries, who have been ostracized for centuries. I don't think we can ever imagine how they were dealt with in the context of the caste structure that prevailed. So, Madad, I think that the constitution makers in 1950, realized this. That is why the notification was issued in 1950. And they also realized that this is not going to stop. Because they gave the power to Parliament, but this is an evolving situation. They gave power to Parliament to deal with the matter. And it's unlikely that this is going to end very soon. It is in that context, Malad, that we must look at this matter. And what we can do, quite apart from reservation. For Malad, the two basic assumptions that Chanaya made, which were wrong, is number one, they considered the scheduled castes in the order as a homogeneous group. They assumed that this represents a homogeneous group. And I will demonstrate to your lordships that that assumption is based on no factual data. That assumption is based on no analysis of that data.
What they hold is that once they find a place in that particular group, then they are all part.
Homogeneous. What's the basis of that? In fact, heterogeneity is inherent in that.
Actually, the homogeneous nature of all the entries is for the purpose of designation.
Yes, absolutely.
They are homogeneous in the sense that each one of them is a scheduled caste. But your argument is that there is no homogeneity either in terms of the sociological profile, economic development, social advancement, educational advancement.
Absolutely. So that assumption in Chanaya was wrong.
Common factor is social and social backwardness, social and economic backwardness. But the degree may vary from one
entity
to another.
Absolutely. So the assumption of homogeneity in Chanaya itself is constitutionally flawed. That's the first mistake Chanaya made. The second mistake Chanaya made was that it correlated the presidential order with reservation. These are the two assumptions on the basis of which Chanaya was rendered. Neither of these assumptions is valid.
Because the designation is for the purposes of the Constitution.
That's correct.
It's not only for reservation, nor is it coterminous with reservation.
I'll go a step further. It has nothing to do with reservation. But that's the designation of this class has nothing to do with reservation. Reservation emanates from the plenary power of Parliament, which is in 16(4) for the purposes of employment.
Because Indra Swani says that it can be done even by executive instructions.
But now not anymore, Malad. Because now it's Parliament has to make a law, Malad.
What?
Now Parliament has to make a law to change the schedule, to change the schedule.
Reservation, Indra Swani goes on to say that it is not necessary that there has to be legislation. It can be done even by executive instructions.
Maybe so, Malad, but that is not part of the notification. But that's nothing to do with reservation. My point is, Malad, you are assuming
that may not be correct, because if there is a reservation for scheduled caste, so unless that particular entry finds in the place in the presidential order, that person is not entitled.
I just demonstrate that to your lordships, wherever they wanted to give reservations, they have given it. Well, then reservation is part of 16(4) itself as
Yeah,
far
I
as
mean,
employment is
it's-
concerned.
It's a necessary but not a sufficient condition.
Correct.
Designation under Article 341
Yes.
is a necessary condition for reservation, but it is not sufficient in itself.
Correct.
Because having been designated, there is still an enabling power which is conferred upon the parliament, or for that matter, as brother says, on the executive.
Yes, but it's the union or the parliament, Manoj, but the order itself has no reference to reservation, and I'll show that from the chapter itself. Manoj, first of all, let me go to the first point.
Yes.
And then I'll come to the second point. These are two assumptions I want to deal with immediately. Now kindly come to PDF. This is volume 4, PDF page 1381. Oh, sorry, 1386. The running page is 1381, volume 4. I'll quickly, Manoj, demonstrate that here also.
Yeah, page 1384.
Manoj, sorry. 1386, volume 4. My lord has it? Your ladyship has it? Just 4 minutes, volume 4. So volume 4, page 1386, Manoj, PDF 1386. Looking at Punjab, Manoj.
Mr. Kasibel, just give me just a second.
Lordship has that?
Just one. Just one.
Sorry.
Volume 4, right? The
Yes,
main
volume 4,
yes.
1386.
Yes,
You have that chart now, Manoj?
yes.
Now kindly look at item 38 on the right-hand side. Mochi. We all know, Manoj.
Yes.
Now look at 34. Sapera. Sapela
I think
means
snake chamas.
snakes.
Snake chamas.
One has nothing to do with the other. Look at Manoj's Bazigar. He indulges in acrobatic feats. Then Batwal Manoj. Actually belongs to the Rajput caste. Manoj is normally a watchman. So what you have an agglomeration of various castes which are put together who have been humiliated for centuries. The heterogeneity is clear from the table itself. I can go on, but there is one Gagra which has only 268 families in Jagraon in Ludhiana. There is a Nut which is an unskilled labor. The Koli is the hunter and a butcher. The Sasi Malads is a criminal, comes from that class.
Korean would be fishermen.
No, but originally came as hunters and butchers. That is item Malads.
So there is heterogeneity in
91.
terms of the pre-existing occupation,
That's right.
in terms of the resources or lack of resources,
Exactly.
in terms therefore of all the indicators of backwardness or development.
Exactly. So therefore they are put in one class.
Social status. The status of every caste may not be the same in the social hierarchy as well.
Exactly. So that
Between them, some may be a little more advanced, some may be a little
Correct.
less advanced, people may be particularly underprivileged.
Correct. Absolutely.
In terms of other indicators like infant mortality, maternal mortality, fertility rates, which sort of define, broadly speaking, whether there has been progress in the social indicators.
Absolutely. Now that assumption was made by a observation of Justice Krishna Iyer in Thomas. And that's at page 135. Sorry, para 135, but let me give you the page. Volume 5, page 84. ADF 84. Yes.
Did Justice Krishna use the word homogeneity or?
No, he said, he doesn't use the word homogeneity at all, Malad. I tell you, Lordship, what he said. Just have a look at volume 5, PDF 84. And this is, Malad, in fact, quoted by Justice Hegde. And then he comes to the conclusion that they are one class. Now just see, Malad, that.
Yes.
May I read it, Malad?
Yes.
We may clear the clog of Article 16.2 as it stems from a confusion about caste in the terminology of scheduled castes and scheduled tribes. This latter expression has been defined in 341 and 342. A bare reading brings out the quintessential concept that they, brackets, there, are no castes in the Hindu fold, but an amalgamation of castes, races, groups, tribes, communities, or parts thereof found on investigation to be the lowliest and in the need of massive state aid and notified as such by the president. To confuse this backwardmost social composition with caste is to commit a constitutional error, misled by a compendious appellation. So that to protect Harijans is not to produce prejudice any caste, but to promote citizen solidarity.
In fact, by using the expression, this mixed bag,
Yes.
the learned judge is really underscoring the heterogeneity of the
Exactly.
Then in the latter part, he says, but as a large backward group,
That's correct.
deserving of societal compassion.
Correct. Now, this is quoted by Justice Hegde and comes to the conclusion that it forms a class. Now, kindly have a look at that. PDF 796, volume 5.
It's 796.
Yes, volume 5. Para 23. This is where the judgment 22 also is erroneous.
The way of doing it is that not to deny that they form a class, but they form a class for the purpose of Article 341.
That's right. Absolutely.
So they may be a class for certain purposes, they may not be a class for all purposes.
That's correct.
Basically what you said in your submission.
There is a level of, what should I say, Mother, discrimination which runs through this entire list. But their vocations may be different, their historical, the way they were treated may be different, there may be so many differences. The numbers may be different. The extent of discrimination also may be different. Level of discrimination may be different. For example, Malas, what we are dealing with are Majbi Sikhs and Dalit Sikhs, Malas. Now, do you know what the origin of this is? The origin of this, what is the origin of Majbi Sikhs? Guru Tegh Bahadur Malas, his body was mutilated. And he brought that body to Guru Gobind Singh. And he was a chamar. The person who brought that body was a chamar. So Guru Gobind Singh took him in his fold. And therefore the chamars became part of the Sikh community. Now, what has that got to do with this list? That's the historical context. Yes, begin. Mazhabi means faithful.
There is also an entry with regard to Chamars
Yes,
in Punjab.
that's right. And that's why, Malas, your lordships find that the 32% of the population of Punjab,
Completely.
32% of the population is Dalits. More than any other state in this country. Sweeper. He was a Chuda. He was a sweeper.
Pishti.
Whatever.
He was a Pishti. One who, yes, water. He was
Water.
a Pishti.
There are others also. With the list also, there are lots of, anyway.
That happened, my lord, near Chandni Chowk. The incident.
Yes, of course.
Uh,
I'm quite familiar with it.
which is that? Gurdwara is there.
Now, Malas, just come to this volume, PDF 796 of the same volume, paragraph 23, where he quotes, Malas, the learned judge quotes Justice Krishna Iyer. That's the 135 that I read to your lordship.
Para?
135.
No, para 23, where he
That is
quotes
the paragraph on that
135,
page,
which
yes.
I've read to your lordships. And then he says in para 24, the learned judge, according to Justice Krishna Iyer, though there are no castes, races, groups, tribes, communities, or parts thereof in Hinduism, the president on investigation, having found some of the communities within the amalgam as being lowliest and in need of massive state aid, including them in one class called the scheduled caste. The secretary thereof is that the scheduled castes are one class for the purposes of the Constitution. One has nothing. That conclusion is ex facie wrong. So I've demonstrated heterogeneity. I've demonstrated, Mullahs, that the basis of the judgment is that there is homogeneity. That assumption is wrong. And on that ground alone, Malas, the judgments must go.
Yes.
Now, sorry. Yes. So, Malas, therefore, now if you read 341 now with me, Malas, your lordships will realize, Malas, that in fact what Justice Krishna is saying is consistent with 341 itself. Kindly read 341.
Prima facie, that observation that it amounts to tinkering with the president list in the presidential order, that doesn't appear to be, because they
Absolutely.
don't say that if you remove comma or
Absolutely.
Nor are they saying that this particular caste is a synonym of whatever is a designated caste. That include therefore this caste. Not is the state of Punjab arguing it, that though
No,
these castes have been not designated, these particular castes are also are synonyms or belong to the same.
Absolutely.
That you can't do. That even we can't do as
Exactly.
it's beyond the power.
Exactly. Now, if you read 341 with me, Malas.
341.
Yes. The president may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the castes, races, or tribes, or parts of or groups within castes, races, or tribes, which shall, for the purposes of the Constitution, be deemed to be scheduled castes in relation to that state or union territory, as the case may be. Heterogeneity is writ large in 341 itself.
Anything else on the first point?
Well, just one point. Your lordship asked the question why the word deemed is there.
Right.
Because I just wanted to answer that because it is there because
that's the learned AG wanted to know.
Because Malaj, it can't be changed till Parliament changes it. It's deemed to be. Nobody can tinker with it. That's the reason why deemed is there. Because 2 says Parliament may by law include or exclude. Till such time as Parliament passes, it's deemed to be. No state government, no central government can tinker with it after the presidential order. So that just to answer that question that arose. Now let's come to the second point that I was arguing.
Yes.
Namely, that this has nothing to do with reservation. Now kindly come, brothers, with the greatest respect, kindly come to the chapter. How it starts. Special provisions relating to certain classes. That's chapter part 16. Now, your lordships will find in this chapter wherever the Constitution wanted to provide reservations, it said so. I'm not saying that the union government cannot ensure that there are, that's not the point, Mullah. That power the union has, that power Parliament has, that's not an issue.
16.4 doesn't refer to reservation.
16.4 does. I'll show, Manas. That also is a misreading of 16.4. I'll show that presently, Manas. Just allow me to take this.
330 expressly says reservation.
Yes. Reservation of seats for scheduled castes, scheduled tribes in the House of the People. Kindly come to 331, 333, 2. Reservation of seats for scheduled in the Legislative Assembly. Then come, Manas, to 334, reservation of seats and special representation to cease after certain period. 335, claims of scheduled castes and scheduled to services and posts. And then, Malas, your lordship comes to the National Commission for Scheduled Castes, which is 338, which, Malas, does this exercise. Because that recommendation is sent to Parliament. Parliament then decides whether to exclude or include. That applies thereafter to National Commission for Scheduled Tribes. And then your lordships will see for the backward classes, 338, 38B. And then you come to Scheduled Caste 341. So the scheme of the Constitution is clear. 341 is meant to identify the heterogeneity of those communities and castes and tribes who have been dehumanized over centuries. The power of reservation, your lordships will find in 16.4.
Mr. Sibal, in any state, is there any reservation under Article 330 specifying the communities which have been included in scheduled caste based upon their population ratio or something like that? No.
No, I don't think so.
Like Valmiki is 5 seats
No.
out of a total of 100 seats,
No,
supposing
no,
coming
no.
for.
So in Parliament, it's only for either scheduled caste or scheduled tribe.
That's all. That's all.
But then there can also be classification in that
There's
also.
No, there's.
There is none. There should not be either, Malas.
Why?
For the simple reason, Malas, the representation of the caste to take forward.
I
the
think as a
interest-
matter of fact,
Yes,
insofar as parliamentary elections are concerned, even a scheduled caste from Punjab can contest in Maharashtra
that's correct.
against the scheduled caste.
That's correct. That's correct. Because when we're talking of reservations, we are talking about education and employment, not representation. No, quick classes, quick different. Your lordship is right, but the problem there is, well, they can contest, each one of them.
Reservation for appointment is.
No, they can contest, Malas. They're not prohibited from contesting. So that's what the privilege is only to contest. That's the reason why.
Higher population will always succeed.
That's true. That may be true.
Of a community which has very little.
Hopefully, Malas, that situation will not arise.
Therefore, there was a debate
Yes,
in the Constitution because Dr. Ambedkar, prior to Pune Pact,
absolutely.
he wanted reserved seats specifically.
That's right.
Then ultimately Gandhiji went on a hunger strike and
Reserved.
Therefore, it was reversed. It was reversed.
And electorate.
Yes, it was reversed. So if you look at 16, Malas, something very interesting emerges. First of all, Malas, let me tell your lordship the difference between 15.4 and 16. Kindly read 15.4 with me. You will find no mention
Reservations.
of reservation.
It's special measures.
Special measures for advancement. This is important.
That's right.
Nothing in article, Malas, let me read the whole. The state shall not discriminate against any citizen on grounds of religion, caste, sex, etc. No citizen shall on grounds of religion, caste, race, caste, sex, place of birth, or any, have, with regard to access to shops, public restaurants, hotels, places of public entertainment, or the use of wells, tanks, bathing ghats, roads, places of. Now, Malas, these special provisions under 341 can relate to this.
that's what the learned AJ argued. that the, and Mr. Parasat also, that Chennai, they failed to consider interplay between 341 and 16.4.
But I'm not on 16.4. In fact, I'm going to make a distinction between 15.4 and 16.
But 15.4 may also comprehend reservations as well.
It does, Malays, it
But
does.
the
It does.
concept of special provisions for advancement
Would
is
include.
broader than just reservation.
I agree, but I'm just only saying
Reservation
advancement.
postulates a quota, while a special provision, maybe
Yes.
quota plus.
Exactly.
It could be relaxation,
Exactly. In other
scholarships,
words,
anything.
The reason why I'm saying this, the reason why I'm.
54 was brought because it was held by this court that there can't be a reservation.
That's right.
In 51,
That's
They struck down community-based reservation.
You are-
Champakam Durai Rajan.
Apakam Durarajan.
Miller, there's a reason why I'm making this submission, Miller, for your lordships to consider, Miller. And that is, there is a symbiotic relationship between 15 and 16.
Symbiotic relation.
You reach 16 only when you are empowered under 15. If you're not educated, you can't get employment. It's simple as that.
For a member of parliament, there is no
I'm
qualification.
talking about in the larger context, Malas. We're talking about 21st century, Malas. We're talking about the 21st century, Malas. Of course, some of them can,
The same
Some
school,
of us-
14, 15, 16.
some of us can hold the highest positions in the country without being, so that's another matter, Malas. Some of us, Malas, have reached corporations, Malas, and managed corporations without necessarily being fully educated. That's not the point. The point is, Malas, there is when you're talking about this section of society, there's a symbiotic relationship.
We must recognize that the Constitution is not prescribing qualifications such as property, education, gender. This was an article of faith.
Yes.
And it was a very visionary provision because ours was one of the first constitutions which did not make your right to contest an election or to hold electoral
Yeah, I
office
agree.
conditional on
I agree entirely. And it's a
conditional on
statutory
gender or property or
We should-
your educational qualification.
I'm with you on that. I'm arguing something different. What I'm saying is if this class of people that you call a class, if you don't empower them under 15, you're not going to get representation under 16.
So in that sense, 15, as you said, they share a symbiotic relationship because unless you create the foundation for employment,
Right.
you not get employment.
That's-
You need a qualified workforce to be
It's only in that
in the
limited
workforce
sense.
in the first place.
It's in that limited sense that I'm talking about this. That's all, nothing more than that. Nothing more than that. Now, if you look at 16.4 now, in this context, it doesn't also talk about scheduled caste, scheduled tribes. But if you go to 16.4A, it talks of scheduled caste, scheduled tribes.
The judgment of this court.
That's right. So if you are not included in 16.4, how do you get reservation and promotions? 16.4 has to include scheduled caste, scheduled tribes because they are backward. They come within the genus of backwardness. So 16.4 is an answer, 4A is an answer that 16.4 includes. Yes. In the volume 4A, Manoj, that I have uploaded, 4C. 4C. Yes, just see, Manoj, I've given to your lordships in volume 4C, page 13. PDF 13. There are various acts that have been passed which is why 341 and 15.4 allows for advancement through various legislative or executive measures.
Reservation could be one of them.
Yes, reservation is one of them. And it's integral. I'm not
The
saying
universe is much wider.
much wider. So therefore, I've given some of the, you have the Karnataka Scheduled Caste, Scheduled Tribe Prohibition of Transfer of Certain Lands Amendment Act. You have Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act. There are all kinds of. You have the Protection of Civil Rights Act of 1955, all kinds. So, Malas, therefore, I just wanted to, and Malas, when we look at reservations, this will never end. This is an unending exercise that we are going through as a nation. The reason is very simple, Malas, that unless 15.4, unless you advance under 15.4, you'll not go to 16.4. So if you look at Malas Punjab, and I'm not going to the numericals of it, but the fact of the matter is that the total population of these is about 280,000. Government post is 280,000, approximately. I'm just giving you a lordships.
Of Mazhabi Sikhs.
No, total government post. The Mazhabi Sikhs and Dalits are about 32 lakhs. Total number of posts are 280,000. Out of that, Malas, 25,000 goes to schedule. 25% goes to these classes, backward classes. Of the 25%, 50% comes to Mazhabi and Dalits.
Mazhabi and Valmiki.
And Valmikis. 50% come to Valmikis. And I am told, Malas, how many seats have been actually? Total. Most of them are not occupied even.
And it's preferential, so it goes to anybody else.
Yes,
then.
and it
No
will
carry
go to
forward.
anybody else. Most of them are not even occupied.
Absolutely.
What does that tell you? What does that tell you? And that's very important. I want your lordships to actually mention it.
That posts are not unoccupied.
Well, they will give you the data. Actually, I've asked the state.
Yeah, maybe there is no adequate representation insofar as Mazhabi Sikhs and Valmikis are concerned.
No, the others also. In fact, I've got some data, but I've asked the state, they'll give you the data. I've asked by this evening, we'll get that data.
Therefore,
But the
your point that unless there is educational advancement under 15 and social advancement,
That's right.
16 remains a teasing.
Dead letter. There'll be cases after cases on the same issue for times to come. And if you can have Kasturba Gandhi schools for girls, why can't you have schools for Mazhabi Sikhs or these communities? Not just for everybody. That's the way forward for the nation. You don't empower them, and then you keep on fighting that there are not enough people in promotion.
All right, yes.
Well, therefore, I beseech your lordships, but this is an area your lordships should say something.
All right, anything further, Mr. Sibal, now?
Yes. Now, Malas, just my written submissions, then I've done, Malas, because I don't want to take volume 1B, PDF page 29. Where is 1B? Yeah. So, Malas, I'm not going to, Malas, take your lordship because there's no time. Just come to the page 54. Para 54, Malas. PDF 27. Just a quick look at that, Malas. The table, why don't you show that table? Yes, your lordships will see that para 54, it's
PDF?
PDF
Page 27.
27. Running page 26. Malas, it says A, Malas, small paragraph A, a study of Punjab caste done in 1883 found Mazhabis belonged to the Chura caste and were primarily scavengers and sweepers as per the report of the Evaluation Committee on Welfare regarding welfare of SC so and so, so and so, for the period commencing 15th August 47, dated 65 to 66, Mazhabis had a total population of 664,000, while Balmikis had a total population of so and so. Said report also found the social conditions of Scandinavia were awfully deplorable. They didn't even have proper access to utensils, let alone housing. They had meager income, were forced to do scavenging despite working from dawn to dusk. The report also noted that educationally they were extremely backward, even more. The literacy rate is around 41%. So Manoj, all I request your lordship is read through this, please, because I don't want to waste your time. This will tell you the situation that we are in. And I'm deeply obliged. I didn't want to repeat anything.
Thank you, Mr. Zulu. Thank you.
What?
Mr. Solicitor,
I think only 10
Okay.
we'll hear the
Mr.
solicitor so that.
No, Mr. Venugopal was on screen.
So Mr. Venugopal should argue
No, no,
first.
I'm sorry. He's
But
on
that's-
screen, he was supposed to go next, but he has said, there's been a bereavement in my family. So he has said that I could go before him. Both him and Mr. Nidesh Gupta have been kind enough to say that. I just want to inform you.
Certainly, you have to leave the
Because you
court.
have an order, that's why.
Certainly.
There's just one issue, Malaj. Indira Sani, paragraph, note it, Malaj, please. PDF 689, paragraph 778.
Just one second.
Yes.
Sani, volume,
Volume 5, PGFK 689, paragraph 778, they explain as to why in 16.4 the word class is used and not caste. They explain. I just read it. Indeed, there is a very good reason why the Constitution could not have used the expression caste or caste in 16.4. And why the word class was a natural choice in the context. The Constitution was meant for the entire country and for all time to come. Non-Hindu religions like Islam, Christianity, and Sikh did not recognize caste as such, though, as pointed out herein above, caste did exist even among those religions on various degrees. Further, a constitution is supposed to be a permanent document expected to last several centuries. It must surely have been envisaged that in future many classes may spring up answering the test of backwardness, requiring the protection of 16.4. It therefore follows that from the use of the word class in 16.4, it cannot be concluded anything else. So therefore, the judges say the word class in 64, in our opinion, is used in the sense of social class and not in the sense.
We'll have a look at
It's
it.
antithetical.
Thank you, Mr.
I'm
Zulu.
deeply.
Mr.
It's okay
Shankaran?
now, we can't, there's, others have to also argue.
Sitter wanted to address your lordship, I think. he has
Mr. Attorney, Mr. Shankaran, there's been a bereavement in his family, so he has to leave. So can we hear him for 10 minutes or so, and then we will, hear him.
You didn't request me for that. Of course we can.
Well, may I be
Of
excused?
course we can.
Want to go? Just volume what? Wait, please. May I just start with expressing my gratitude to all the seniors who should have gone before me, who have been kind enough to let me go before them. I'll just keep it very brief. There are just 4 points that I want to make. If your lordship would be kind enough to have volume 4B, B for Bombay.
What is the first point that you would make? So then we'll take it.
I'll address the 4 points. The 4 points are these. First, that in identifying the scheduled castes and scheduled tribes, a bit of a historical context is necessary. Because eventually we're talking about how you will classify within these groups for the purpose of giving them measures. So the historical context will broadly show you how they first come to be identified. Why are they forever called scheduled castes? Where does that schedule come from? It comes from the Government of India Act 1935, and there's a background behind it. It starts with the census in 1891. I'll briefly touch upon that. All of that is in volume 4B. The second, this will also briefly touch upon that question that fell from the bench yesterday about why tribes, the word is used while defining scheduled castes.
In 341 also.
Yes. Why is it used there as well as in 366? In both places, scheduled castes are including tribes. Why does that happen? The second, my lords, is that the constitution and its approach towards scheduled castes and scheduled tribes. You'll find that it was a very, very important and integral part of our constitution making, starting from the Pune Pact, starting from many other big leaders, both from the Dalit community and outside, who were responsible for ensuring that many provisions of the constitution were infused with this, taking steps. Article 15, which has provisions which come from the Pune Pact, Article 17 and its abolition, exploitation provisions in 23. All of these, along with 15, 16, yes, of course, that's what we keep dealing with. But we must draw a small distinction between 15 and 16, which are provisions which are not automatic, which don't immediately give a right to a member of the backward community. It is for the state to make a law under 15, 16 if it so wishes. So 15, 16 are enabling provisions. 330, 332 and the provisions dealing with municipalities and panchayats give them a right. So how that started and that context under the constitution will perhaps help, I think, this bench in looking at the context in which we are arguing this case. Because in my view, at least my submission is that this subclassification is to be done at the end when the enabling provision is being activated. It is at that end that you decide while dealing only with 15, 16. That subclassification cannot be, and I think it came in the discussions earlier today, in 330, 332, etc. That can't be done. It's on 15 and 16.
Or the Panchayat Raj and
Yes,
municipality.
or panchayats or municipalities. That's the second limb of the submission.
Yes.
The third, it's been touched upon by Mr. Sibal. I won't spend too much time on it. The error in Chinnaya, while looking at the Thomas paragraph of Justice Krishna, in fact, I'll make this point right away. It's just that this is an editorial intervention, an unnecessary editorial intervention in the SEC volume, which has caused this confusion. What exactly happened is in N.M. Thomas, Justice Krishnaiyer uses the word they, T-H-E-Y. He uses that to refer to the various groups, etc., who are the Dalit community. He says that they aren't part of the Hindu groups. Unfortunately, when the editor published in SEC this judgment, within brackets, it put SIC, sick, there, T-H-E-I-R. Now that there is treated by Justice Hegde in Chinnaya to mean, therefore, a complete homogeneous group. They and there made a big difference. I'm just making this submission. The Lordship may see those 2 paragraphs, but I don't want to spend too much time on that.
Right.
And finally, there are a few questions that fell from your Lordships yesterday. I just want to address each of them. I think there were some doubts that your Lordships had. So I'll just do that briefly. If your Lordships, the first main limb is going to be the first 2. 4B, volume 4B, B for Bombay, of the compilation. And I'll quickly go through that.
Editorial mistakes can sometimes cause very grave blunders.
Correct.
In fact, when we wrote I wrote the 7-judge judgment on the Arbitration Act.
Yes.
It was an editorial blunder in one of the private publications which was handed over to the bench. which pointed out that a particular provision was brought into force when it was exactly to the contrary.
Oh, it wasn't brought in. Well, that's very risky, Manoj. 7 judges we should.
And
be
it
careful.
was, so we noticed that and corrected the error in 7 judges.
Well, so if I can trouble your lordships with volume 4B. 4B for bomb. I'm sorry, yes.
What is the fourth? Volume 4B?
4B, B for Bombay.
This is your fourth point.
No, this is the volume for my first point. I'm just taking your lordships to the compilation.
The queries raised.
Compilation, volume 4B.
Volume 4B.
Yes. Yes. Not right now. 4B, my lords, if your lordships will take the first page, that's the census report of 1891. The lordships have that? Census, that's page 2 PDF as well as running page.
No.
Same.
No.
That is Dr. Ambedkar Foundation, that is writings and speeches.
Volume 4B for Bombay,
Yes,
4B.
4B.
Dr. Asa Ambedkar writing and speeches, chronology of events.
What's the nodal council?
No, I've been told. 4B.
No.
No, we have downloaded it as Roman, it's Roman 4B.
Roman.
Roman 4B.
It's for others also, it's census report, I'm sure, sorry if there's,
Roman
correct.
4B.
the one your lordships are referring to is 4A.
4B.
Oh, 4B. Oh, sorry. Then would your lordship check 4A? Because we've all been told that it's 4.
Also has some reference to Norway incident which Mr. Faraz yesterday mentioned.
Okay. So I'm sorry.
4A has Constituent Assembly debates, etc., etc. The tyranny of merit, Michael Sandel,
Let me check which volume this is.
meritocracy trap.
Huh? Could you?
I can wait in.
Just
you
a
can-
minute. 4C, 4D. Sorry. 4B. Oh, this is. Yes. What do you say? No, let it be. I'll just address them. Look, it's filed a volume. The further compilation. It's not there. No, we checked with the nodal council. He said it's been uploaded. If it's not, I'll just anyway address your lordships then. It's going, we'll go right now. Okay. But they're just uploading it. I'll just address your lordship. I don't want to take time. I'll just briefly tell your lordship what it is. There is an 1891 census report. It was the first census report. Now that census report went into a detailed enumeration. At that point of time, what they did is they went through occupations because throughout the 19th century, the British had come up with many reformist processes from their end as far as the Hindu community largely was concerned. Your lordships know everything with reference to Bentinck's reforms, etc. But towards this end, they wanted to find out what the various occupations were because they found that within the large Indian communities, you would not have intermarriage, you would have people living on the edges, not allowed to share water, not allowed to eat, etc. together. And they looked at the various occupations because many groups were being excluded completely from the occupations. So occupation-based census is this one of 1891. And this provides for the manner of the enumeration, the classification of the occupation, and they specifically say that with reference to these, what they came to refer to as depressed classes, that's the phrase that they used to use then until it was dropped in 1935. The depressed classes, they said that there were many, even within the Rajputs and the Jats, they didn't look at them as castes, they looked at them as tribes. That is where, my lords, this notion of tribes for the purposes of the depressed classes. We are not right now talking the scheduled tribes, scheduled castes. With reference to them, they referred to them as tribes. And they mention community-wise the various groups which are dealt with, which includes 10 minutes. the various tribes. And they divide them into various classes. Class Roman 7. Class 7 are known as the menials. Those are the ones today who have been come to be described as the scheduled caste. This is stage 1, 1891. The next one is 1930, which is the Indian Statutory Commission, which goes in detail into these depressed classes. The phrase depressed classes eventually came from a report of 1918, which became a part of the Montague-Chelmsford reforms. But they refer to they use the phrase, employ the phrase depressed classes. They look at these statistics from previously and say nearly 20% of the population belong to these classes. They say that these classes are partly functional and partly tribal, and they mention the various types of disabilities that these groups have been suffering over a period of time. The 1931 census is the third in this sequence. And it was carried out by a famous anthropologist at that time, Mr. Hutton. And he says, for the first time, he refers to primitive tribes. This is where the concept of scheduled tribes come in. They say that there are many tribes because the exploration of India for the British census takers was taking time. So they reached Nagaland, Arunachal, etc., and discovered many tribes which are nomadic or in jungles and forests, etc. And they refer to them as primitive tribes who haven't really come in contact too much with society. And they refer to them. 1931 is the first time that you find that there are these primitive tribes as well. This is for the purpose of the identification. And they shift in 1931 from depressed to referring to them as the ones formerly known as untouchables, and say that we shall refer to them as the scheduled caste. Now, the reason why scheduled caste is that in Government of India Act 1935, they eventually laid down that for representation in the federal legislature, there would be a first schedule to the Government of India Act, which would provide how the various communities were going to be represented. Now that, I think they're just transferring it. That is the one thing I'd like your lordships to see. Because all these communities that you find, where did in 1950 did the president suddenly get this list? He got this list from the first schedule of the Government of India Act 1935.
Right.
And we continue to refer to it as scheduled caste and scheduled tribe because of the schedule in the 1935 Act, nothing to do with the Constitution itself.
Right.
It's come. Can your lordships now see it, Manoj? It's on screen.
Yes.
Yeah, I can see that. It's good. Just if I can trouble your lordship, I've told your lordships the first, that's the 1891 census report. Then the next is that statutory commission report. There are page numbers. I'll give that to you on a single note, my lords, because I want to keep it short. And then is the 1931 census. And then the Government of India Act 1935. If your lordships would be kind enough to come to page 58, that's where the
I
act
didn't do
starts.
this with Shankaran.
Yes,
Today you have cleared the court, but you can add to your submissions
Yes.
just an addendum
yes,
and make sure it goes into our copy.
I'll do that.
So that, then you can also, we'll label this particular compilation as volume whatever.
Yes,
You can give us a 2-page note
I'll
on
do
the evolution.
I'll do that.
And I think that.
This is why I'm trying to keep it short. I'll just highlight what I'm saying. Just for a minute, if I can trouble your lordships only with of this volume, page 185. This is the first schedule. The lordships can see that. It's marked. It's the first schedule to the Government of India Act. And in this, my lords, entries 4, 8, 18, and 20. Your lordship may note that. Entry 4, for example, I'll just read to your lordships. To each governor's province, chief commissioner's province, and community specified in the first column of division 1 of the table, there shall be allotted the number of seats specified in the second column opposite to that province or community, and of the seats so allotted to a governor's province or a chief commissioner's province, the number.
Was the expression scheduled caste defined in the,
It is defined. It is defined in 26. Yeah, but I'll just, 4, 8, 18, 20 refers to scheduled caste,
Yeah.
and 26 defines scheduled castes. So it's the exact same definition that you find now in the Constitution of India. 26. Can they go down? Can you scroll down? 26. That's at, I'm sorry, that's at page 189, PDF 189, the middle of 189. Yes, the scheduled caste means such castes, races, or tribes, or parts of or groups within castes, races, or tribes, being castes, races, tribes, parts, or groups which appear to His Majesty in council to correspond to the classes of persons formerly known as the depressed classes, as His Majesty in council may specify.
In the scheduled caste.
So this is copy pasted effectively and put in the constitution. Immediately after this is the scheduled caste order of 1936 by the King and Council, Manoj, which is at page 253. It's very interesting. The previous year, 1935, Government of India Act is by George V. This is by Edward, who abdicated, as your lordships remember,
Yes.
because of that. So in the 1 year that he was king, page 253, this is issued, first paragraph, page 253. Whereas by certain provisions in the first, fifth, and sixth schedules to the Government of India Act, His Majesty in Council is empowered to specify the caste, race, or tribes, or parts of the groups within caste, race, or tribe, which are to be treated as the scheduled castes for the purpose of those schedules. And it's not only schedule 1, but other schedules as well, as you'll find from para 2 of this in the middle of the page. Subject to the provisions of the order for the purpose of so-and-so schedules, these are the ones who will be specified. Para 3 is interesting. It says, notwithstanding anything in the last preceding paragraph, no Indian Christian shall be deemed to be a member of the scheduled caste. No, in Bengal, no person who professes Buddhism or a tribal religion shall be deemed to be a member of the scheduled caste. This is after the partition of Bengal.
Yes.
And next page onwards are the castes. So this is the castes, tribes, all of them, state-wise, as per those states, Madras, etc. Now, this in its entirety, this goes on for several pages more. This in its entirety, community-wise, was what was replicated in the presidential order of 1950. The presidential order had to be amended a few times every time we had a reorganization of states, because it was unclear whether that community will remain an SC for that partitioned state or not. So they did. Every time there was a reorganization in 56, 59, they did actually amend the presidential order of 1950. I'm quickly coming to my second limb. This is to give your lordships context and to say that these are the groups. Therefore, at a later stage, when you come to enabling provisions, when you decide to give those communities, if some of those communities have been, say, for 16, adequately represented, then it is incumbent on the state not to repetitively give them who are adequately represented that benefit. I think that point has already been made repeatedly. Second, I'm just handing this over. It's there in this volume as well. It's there in the volume, yeah? So just take 7 copies. This, Malaj, is something I had submitted in the EWS reservation case, the 5 judges, just which has been included in the Janhit Abhiyan judgment, in fact. It's a chart showing reservation provisions under the Constitution. All the provisions are here, which are dealing with this, just to help address your lordships on. It's in this also. It's at page 805 of this volume. It's at page 805, but I'm just addressing it from here, if I may. This is to show the provisions, Malons, which govern each of these communities. The central one, the red one, is SC/STs. The one outside that is SCBC, OBCs. And the one at the outermost is EWS. We can ignore EWS for the time being. SC/ST, the definition provisions are there. Then the special provisions are there. Now, why we have color-coded it separately is for the parameter that has to be applied. The parameter that has to be applied for the scheduled castes and scheduled tribes with reference to 15 and 16 is historic untouchability. Because I think there has been a general sense that social and educational backwardness is the determinant for being an SC/ST. That's not true. For being an SC/ST, it is about its historical backwardness and it's a constitutional atonement for those years of discrimination. So for determining who the scheduled castes are, and this is what even the 5 judges decision in Mari Chandrasekhar says. Specific paragraph I'll give you, it's para 9 of Mari. Mari is, I'm sorry, it's not part of this volume, but it's the paragraph is extracted. It says that it's the historic untouchability which is for the determination of SCs. Social and educational backwardness, which is defined in the Constitution in Article 366, says for the purposes of this Constitution, socially and educationally backward are those who are determined by way of the list which the President provides. But that came in by way of an amendment, that definition, because after the Indira Sawhney judgment, the Indira Sawhney judgment gave one direction to the government. It said that please ensure that you set up a national commission for the backward classes, and they set up a national commission. There was a National Commission of Backward Classes Act. Subsequently, when the Constitution came to be amended, that National Commission was taken and put on a constitutional plane from statutory to constitutional. And therefore, the definition had to be given of who are socially and educationally backward classes. Now, there has been a little bit of debate in the past whether socially and educationally backward classes is the phrase used in 15. It's not used in 16. In 16, you say backward classes, which is why you get the O in the OBC. You have SCs, STs taken anyway to be backward classes for purpose of 16. Other backward classes are those outside of that. Are they the same as the SCBCs? The Constitution seems to suggest to us, courtesy all these amendments that have come, that they're perhaps the same. We don't have a fourth list of OBCs. We just have the SCBC list. That's the one that's adopted. But for determining the scheduled castes and scheduled tribes,
Historic untouchability.
it's historic discrimination. So that pink one shows that that's historic untouchability. Well, the reason why I put the blue ones, your lordships will see,
The political backward,
political backward.
political reservation.
So in municipalities and panchayats where you have these provisions, as well as in the Lok Sabha and the legislature, these are the political backwardness determinations that have to be made. The third, of course, are the social and educational backwardness, which are in yellow. Now, one small distinction, I think, which is essential for answering the question that has been referred to your lordships is simply this, that the idea in the Constitution at the time the Constitution came in, the SC/ST communities had only one provision of reservation to them, which are the ones in 330 and 332, nothing else. As a provision of reservation available to that community, it was only in the legislatures and parliament. Subsequently, when enabling provisions were activated from the outset, from Champakam and Venkatraman, both decided in 1950, or one on 15 and the other on 16, there was an activation of that. Even though the GO was prior to the Constitution, there was an activation of 15 and 16. Once you activate 15 and 16, does the state not have the right to say that, look, your list which the president has made, that remains intact. I'm not trifling with it. But for my purposes, where 15 and 16 gives me the right to make a measure,
Yes.
I believe that these communities need to be favored. Now, whether the choice of those communities by me is right or wrong will be determined based on reports, based on other data. The Indira Sawhney judgment says use the barium chemicals
Yes.
measures to determine that. But that list remains intact for the purposes of the political representation. So for municipalities, panchayats, legislature, and Lok Sabha, I can't touch it. The state has absolutely no role to play in that. That remains. I hope I'm making myself
Yes.
clear. So that distinction is necessary. This entire debate here is really only about 15 and 16. Because the definitions, both in 340, 342, as well as in 341, 42, as well as in 366, make it clear for the purposes of this Constitution. So the SC/ST determination or definition for the purposes of this Constitution encompasses the mandatory political representation for which the state has no role to play at all. It can't interfere in any way. And where the state has a role to play. It's only in that where the state has a role to play under 15 and 16 that it is the entitlement. In fact, it's a constitutional obligation of the state to make such determinations. So this chart is for that purpose.
We've got the point. Should we
Yes.
now close?
The last thing is to address those questions. Well, one more. There's a judgment of your lordships, which is in this compilation at page 353, my lords. This is a small concept which may be relevant. This is a judgment of my lord, the Chief Justice and Justice Shah in 2021. This is at page 353.
Yes.
Patan Jamal Wali. It was dealing with the outrage, the rape of an SC/ST lady who was also blind. Now, two paragraphs just see para 17 at page 372, internal 372, para 17.
Yes.
This principle of intersectionality, I comment to this bench. Intersectionality can be defined as a form of oppression that arises out of a combination of various oppressions, which together produce something unique and distinct from any one form of discrimination standing alone. While the model of intersectionality was initially developed to highlight the experiences of African American women, there is a growing recognition that an intersectional lens is useful for addressing the specific set of lived experience of those individuals who have faced violence and discrimination on multiple grounds. A single axis approach to violence and discrimination renders invisible such minority experiences within a broader group, since it formulates identity as totemic and homogeneous, which is precisely what Chinaya has done. Each of these communities have lived experiences which are distinct from each other. Even in Indra Sani, I'll give you a lot of the paragraph, there is a acceptance. Justice Krishna and Anam Thomas says that even within the scheduled castes, they're not all alike. They're all very, very different. They have different experiences. But I won't read the rest of the paragraph, but I believe this paragraph
Yeah.
and
Para.
para 795 of Indra Sawhney. Both of these, your lordships may just consider. Now, quickly, I'll just address the questions that came yesterday. Justice Nath had asked a question that once people have achieved to a certain extent, wouldn't you remove them from the list? That's not a call for the state to take for two reasons. One, that they don't have the power, that's for the president to do on recommendations by the state. But when they've reached that level, you have to see that they've reached that level not only in my domain of 15-16, which is education and employment and everything else
Why
socially.
can't the state take that call? State
No,
can always
because
do it.
the
Once
removal
the
from
state
the
is deciding to
Yes.
allocate extra percentage of reservation for specific communities
Yes.
within that scheduled caste group,
Yes.
it can say that these are already adequately represented, they don't require any reservation.
Yes.
Why not?
No. So the
That the
problem is
state has
this.
to implement
The
41.
under 15 and 16,
Yes.
it becomes implicit because the state, when it's giving its reservation, says, I choose these 10 communities and I give it to them. So the
64
others get excluded.
64 is backward class.
Yes.
You can always say this backward class does not require any further.
No, I
reservation
don't think the
because it's
negative
adequately
declaration
represented.
is necessary when they
State
positively.
exercise, not
So
the
the-
parliament exercise.
So if they give the entire extent of their reservation,
They can
so say
continue
10
the scheduled caste
communities.
to gain
Yes.
advantage of 15-4 or
Yes.
any other provision,
No.
or
So,
330 or whatever.
yes.
But for
So,
16-4 is concerned,
yes.
they can always exclude.
Yes, so that comes to the second question, my lord. The Chief Justice posed to the Advocate General yesterday. If there are only two communities and you decide, can you give entire 100% of the reservation to them? My answer is different. My answer is yes, you can. Because the idea of this constitution is that at some point you will, because you'll reduce from your 100 caste groups. Hopefully, we are moving forward as a nation. If you keep moving forward as a nation, some of these communities will get adequately represented, will move forward. So from 100, you'll come to 50, 40, 30, at some point you'll come to 2. And you'll say, look, these two are so terribly ravaged that there is no question that I'm going to give my 100% of that reservation available to me to them. Both the quantum, that is percentage, as well as the number of communities is in the state's hand. So the state doesn't have to give 40%, it can give 4% reservation and say the entire 4% will go to two communities. So that's to answer the second question, Malad, which I believe that would be the correct answer, the consistent answer, because this constitution and its interpretation not for today. When we have 7 judges going into this, 20 years from now, we may hopefully reach a stage where we will have only 2 communities and we'll be able to take care of them also. And this, yesterday, Justice Gawai had a question about the creamy layer application in the SCSTs. Now, Nagraj said so, saying that 16.4A, 16.4B as a constitutional challenge can be sustained only if it has these controls: efficiency under 335, administration, the adequacy, and creamy layer. In Jarnail, when that question had to be referred to a larger bench, they said we're not referring to a larger bench, but this backwardness determination for SCSTs is not necessary, it's implicit, removed that, kept the other 3 intact, reiterating the fact that creamy layer applies to SCSTs. So creamy layer applies to SCSTs because it's an individual removal. But in practice, on the ground, there has been no office memorandum that I know of, the state may assist, which they have issued for the creamy layer removal among SC/STs. They have one old 1992 office memorandum which removes the creamy layer for the backward classes, which is detailed, which has, politicians, members of parliament, etc. Then income criteria also. But
Shankar, we'll close it here.
I'm grateful, madam. I'm very grateful.
Should we hear Mr. Venugopal first? That was what,
Yes.
Mr. Venugopal,
They've taken.
are you online?
Yes, I am on the line.
Yes, Mr. Venugopal.
Great, please, Lordships. Lords, much has been covered. And my
Manoj, sir, may I take your leave? I'm sorry.
Yes, sir.
Please.
I'm appearing, Lords, for the Madiga Reservation Porata Samiti. And it's item number 701.22. And it's writ petition 562 of 2022.
You are for the intervener,
No, my lords, I am for the petitioner.
for the petitioner.
Yes, I think,
But only,
Ms.
Mr.
Shraddha is,
was the
Ms. Shraddha is for the intervener.
the rest are the petitioners.
No, my lord, so far as this is concerned, I had appeared before the 5 judges in the Andhra Pradesh High Court in Chennai. They had upheld the subcategorization of 61 scheduled castes into 4 divisions based upon their advancement over the years. And they had given, my lords, 7% to the weakest among the weak, 6%, my lords, of the jobs and educational institutions, seats, to, my lords, another group, and to the best, to the highest among them, 1%, 1%. This was upheld on the basis of categorization was permissible. Chennai, my lords, reversed it and said that the whole of them being a homogeneous group, this cannot be done. Now, the basis of, my lords, the subcategorization was an elaborate 200-page, my lords, investigative, my lords, report of Justice Ramachandra Raju. And the judge, my lords, after elaborating this, found that there is vast disparities between the different groups in the 61, my lords, subcastes, some of them being, my lords, workers in leather, the scavenging, and, my lords, nomadic, and so on, who had been excluded to a very great extent, so that the fruits, my lords, of reservation had been taken over by the more advanced ones among, my lords, the entire group of 61. And that is the basis on which, based on this comparative advancement, my lord, of the groups, he had grouped it into 61 into 4 groups and had given varied, my lord, representation. Now, this is, my lord, what was held by Chennai and, my lords, was reversed by the Supreme Court of India. Now, my submission to your lordships is this. Article 14 of the Constitution, my lord, is a golden thread which runs right through the entire provisions of the Constitution. At the very inception of the Constitution, the founding fathers had examined the disabilities of various groups and had provided in the original Constitution itself for affirmative action for the purpose of their upliftment. And therefore, my lord, if your lordships would be pleased to take my written submissions, which is a short 10 pages.
1G.
It is
Where would we find them? Where will we find them, Mr. Venugopal?
volume 1, capital G, my lord.
Yes. Just a
Your
second.
lordships inclined.
Give us just a moment so that all of us can access it.
One G.
Yes, it's page 1.
Your lordships will find, if the lordships would be pleased to go to page 5. The various steps taken, my lords, by the founding fathers themselves
to ensure that unequals are treated equally with the rest of their category to which they belong. And at the bottom in paragraph, my lords, 11 of page 5, your lordships will find article 15.3, special provision for women and children. Your lordship have got it, my lords. Para 11. I hope your lordships have it. Para 11, my lords, at page 5.
Yes, Mr. Chairman.
And then para 12, 15.4, that is the backward classes. Then it goes on like that. 15.5, scheduled caste, scheduled tribes, admission to private institutions. Then economically weaker sections, 15.6, which your lordships upheld, 10%, my lord, in addition to the 50%, and 15.6b, 16.4, 16.4a, 16.4b, 16.6, 17, untouchability, and 18, which is, my lords, against against titles to citizens, which your lordship has held in one of the judgments, Indian young lawyers, that some people are being placed above the others, and this cannot be permissible, and that is why. Therefore, so far as, my lords, the benefits are concerned, it is in regard to the state has given benefits socially, educationally, in employment, and politically as well. And your lordships will find that politically, it is in article, my lord, when the panchayats were introduced, in para 22, that is seats for scheduled castes, scheduled tribes in panchayats. Similarly, my lords, in regard to, my lords, the municipalities, then the benefit, my lords, to women, where they are given 1/3 of the total seats, rotation of the chairman, where the women will be given, that also. Now, this is, my lords, the broad basis on which the Constitution had approached, my lords, these inequalities which have been prevailing in the population, my lords, of this country. Thereafter, my lords, they found during the course of the working of the Constitution that there were certain, my lords, classes which stood again deprived of what would be, my lords, an equal treatment under the Constitution. And therefore, my lord, amendments were made. And that is how, my lords, so far as the benefits to scheduled caste, scheduled tribes, to entry to, my lords, the educational institutions, including, my lord, private institutions, was provided for. Economically weaker sections were given 10%, irrespective of religion, caste, creed, etc. Now, similarly, very many other amendments. Now, in this background, I will request your lordships to go to Article 28.2 of the Constitution.
Or 38.2, right? 38.2.
28.2. And this, I say, is the fulcrum on which the entirety of, my lord, the problem is to be approached. 38.2 is, my lord, so far as this is concerned, in the directive principles. The state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst individuals, but also amongst groups of people residing in different areas or engaged in different vocations. Now, so far as this is concerned, it was brought in by an amendment of 1978. Now, this would say that so far as inequalities are concerned, they have to be minimized, not only, my lords, that in regard to status, facilities, and opportunities, not only among groups, but also among individuals. And if your lordships would turn to Article 37 application of the principles contained in this part, the provisions contained in this part shall not be enforceable by any court, but the principles therein as laid down are nevertheless fundamental to the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Therefore, my lords, 38(2) is fundamental to the governance of the country, and it shall be the duty of the state to apply these principles in making laws. And this is exactly what the state of Andhra Pradesh has done. And therefore, my lords, the question is whether 341 should not be read along with Article, my lords, 382. There are a number of judgments, my lords, which say that so far as directive principles are concerned, they should be read along with, my lords, the fundamental rights, along with the other provisions of the Constitution.
Right from Keshavanand Bharti.
Yes, right from Keshav and the Bharati. And my lord, Unikrishnan versus my lord, Unikrishnan versus State of Andhra Pradesh, that is Jivan Reddy's judgment, 1993, Volume 1, Supreme Court Cases, 648. 645. Unikrishnan versus State of Andhra Pradesh. And this, exactly. From Keshavan and the Bharati, Justice Chandrachud, at para 161, is extracted. As I look at the provisions of part 3 and 4, I feel no doubt that the basic object of conferring freedoms on individuals in the ultimate achievement of the ideal set out in part 4. May I say that the directive principles of state policy should not be permitted to become a mere rope of sand. If the state fails to create conditions in which the fundamental freedoms could be enjoyed by all, the freedom of the few will be at the mercy of the many, and then all freedoms will vanish. My lord, similarly, there are a number of judgments which, my lord, would require the harmonizing between directive principles, my lord, and the provisions of the Constitution. Therefore, my lord, the golden thread which runs is not only, my lord, that Article 14, that all persons should be treated equally, but not in that unequals have to be treated also equally, and they'll have to be equalized. And if your lordships will take my written submissions, there is an extract, my lords, which brings this out very vividly. And that, my lord, is Mari Chandrasekhar Rao, referred to in other contexts. But if your lordships will be pleased to turn to page 4, para 9 of my written submissions. My lord, the extract, if your lordships will skip the first 10 lines and come to those who are unequal in fact. I hope your lordships have that. After 10 lines from the top. Equality, which must cover every process of equalization. Or shall I read it from the top of the...
That's fine. Those, we got it actually. That's the correct extract. Those who are unequal in fact.
Yes, yes. And later, those who are unequal, in fact, cannot be treated by identical standards. That there may be equality in law, but it would certainly not be real equality. Existence of equality of opportunity depends not merely on the absence of disabilities, but on presence of abilities. It is not simply a matter of legal equality. De jure equality must ultimately find its raison d'etre in de facto equality. The state must therefore resort to compensatory state action for the purpose of making people who are factually unequal in their wealth, education, and social environment equal in specified areas. It is necessary to take into account de facto inequalities which exist in the society and to take affirmative action by way of giving preference and reservation to the social and economically disadvantaged persons or inflicting handicaps on those more advantageously placed in order to bring about real equality. Such affirmative action, though apparently discriminatory, is calculated to produce equality on a broader basis by eliminating de facto inequalities and placing the weaker sections of the community in a footing of equality with a stronger and more powerful section, so that each member of the community, or whatever is his birth, occupational, social, or position, may enjoy equal opportunity of using to the full his natural endowments of physique, of character, and of intelligence. Now, my lord, so far as this is concerned, your lordship should note that the result of not, my lord, making a subcategorization would be that those who are already more advanced than, my lord, the weakest of the weak, which is a phrase which has been used, my lords, by Justice Krishna here, the weakest of the weak will fall to the ground, and those who are more advanced will take the lion's share, so that this reservation is meaningless and has no effect whatsoever in neutralizing the disadvantages which were sought to be cured by, my lord, the reservation. Now, in this connection, my lord, the words of Justice Krishna here in N.M. Thomas has been extracted at page 9 of my written submissions.
Yes.
And your lordship should be pleased to say at page 9, para 28, the extract from State of Kerala versus N.M. Thomas, page 363 of the judgment, para 124, innovations in administrative strategy to help the really untouched, most backward classes also emerge from such social legal studies and audit exercises of dispassionately made. In fact, research conducted by A.N. Sinha Institute has revealed a dual society among Harijans, a tiny elite gobbling up the benefits and darker layers sleeping distances away from the special concessions. Therefore, my lord, the Harijans are, my lord, the most backward classes among the scheduled castes, a dual society among Harijans, a tiny elite gobbling up the benefits, and the darker layers sleeping distances away from the special concessions. And that is what, my lord, the state of Andhra Pradesh sought to do, which was reversed, my lords, by the by the Supreme Court of India. My lords, your lordship will find the citation at the bottom of that page of Jarnail Singh versus Lakshmi Narayan Gupta, 2018, 10 SCC 396. This is a 5 judges bench presided over by Justice Rohinton. And there, my lords, I had argued as Attorney General that E.V. Chinnaya would stand in the way of the principle of the creamy layer, which was upheld for OBCs in the Indrasani judgment from being applied to scheduled castes. And therefore, since they are only one homogeneous class, you can't subdivide it and remove some of them. Now that was rejected, and the same entire judgment focuses on what was held in N.N. Thomas. And following that, the lordship held that so far as the creamy layer is concerned, they have to be excluded even from the category of scheduled castes. The result of this is that a constitution bench of this honorable court has already taken the first step forward by dissenting from Chinaya to the extent that they have said that a subclassification can be made.
Yes.
I may mention, my lords, that after the judgment in Chinaya delivered by the Supreme Court of India, the government of India, Union of India, wanted the whole issue of subclassification to be, give me the entire issue of subclassification to be gone into by, my lords, the committee, and for which, my lords, Justice Usha Mehra was appointed then by the central government, and which constituted a national commission to examine the issue of subcategorization of scheduled castes in Andhra Pradesh with Justice Usha Mehra as chairperson. This was, my lords, on 16th of November 2006. And the judgment in Chinaya's case by the Supreme Court was on the 5th of November 2004. Now, Justice Usha Mehra went into the issue elaborately, and her report is at page 345 and goes on to 506. And finally, my lords, where do you find it?
Volume 3A,
It is in volume 3, capital A, my lords,
page 446,
at page 504,
446, then
at page 446.
this is 446. It begins at 285.
It begins at 285, my lords, in your lordships.
Page 446.
No, what is this?
444,
And if your lordship should be pleased to go to page 44,
446.
444. And at 33.
Volume 3A, page 444. Volume 3A, page 4.
Volume 3A,
Page 444.
page 444. Just-
Actually, our PDF, page 447.
Paragraph 23.
At 33 minutes. Repeat it.
Page 444. Of volume.
Volume 3A, page 444 minutes. Is para 33.
This is for subcategorization.
The analysis of data, your lordship about it?
Mr. Venugopal, we read that actually. We've seen that.
Yes. Para
Anything
33.
else? Anything else, Mr. Venugopal?
Yes,
Or-
no, I am closing with this. Please see, my lord,
46.
page 446,
Yes.
para 37. The commission thus recommends that Article 341 of the Constitution of India be amended and clause 3 thereof may be added as under 341 clause.
A clarificatory amendment, actually.
Yes.
A clarificatory amendment.
By law provide for subcategorization,
It was eventually never made.
subcategorization of caste so and so within any caste, race or tribe.
So your argument would be that even in the absence of such an enabling provision, the power is always there in the state.
Well, that is what I had relied strongly on Article 38(2), which mandated that your lordships would ensure, my lords, that even individuals who are oppressed or suffer from disabilities as against their similarly placed persons should be given, my lord, equal treatment. Therefore, Chennai in saying that it's homogeneous, it can't be broken up. It can't be the more weakest of the weak. We'll have to suffer total deprivation so that whatever benefits are being given really is a rope of sand, as Chief Justice Chandrachud delivered it. That I submit has to be neutralized.
Thank you very much. Thank you, Mr. Venugopal. Mr. Attorney General, would you like to open? Yes.
Volume 1K, I think, in my written submissions. I'll quickly read. There are only a couple of paragraphs in N.M. Thomas and Chennai, which I may like to draw your lots of attention
Yes.
later.
Volume 1A, right?
1K.
That has not come.
Acha.
It is on the screen, please.
To go to?
On the Lord's have that volume.
Yes,
1K.
we've got it on the screen, yeah.
Let me quickly take your lots of
And after all of you will also have learned attorney submissions on your
It will be
screens.
shared with all,
On the screen before you got it.
Well, the field assigned to Article 341 and 342 and the Equality Charter contained in Articles 14 to 16 are distinct. The domain of Articles 341 and 342 is confined only to the identification and enumeration of scheduled castes and scheduled tribes for the purposes of the Constitution. What shall be done to effectuate the purpose of the Constitution is not a matter that will fall under the domain of Article 341 and 342. Notification in Article 341 and 342 is the foundation by devising provisions of advancement with the meaning of Article 15.4 and equality of opportunity and provisions for reservations with the meaning of Article 16.4. That is why Articles 341 and 342 talk about specification of castes, race, tribes, or parts of groups within castes for the purpose of the Constitution. This means all purposes of the Constitution in relation to scheduled castes and scheduled tribes. Except where there are express constraints, no dissonance between two constitutional provisions should be either suggested or accepted. Therefore, Article 341 is not to be seen as a limitation or a constraint in what can be done or what needs to be done under the Equality Charter of the Constitution, Articles 14 to 16. The dynamics of equality of opportunity and advancement measures will lie in the domain of Articles 14 to 16 and may not be controlled by the mere enumeration authority given under Article 341, 342. The spread of equality of opportunity and the distribution of equality measures are essentially matters that will be addressed by the state and not by the president. The E.V. Chinnaya is premised on the understanding that all the castes and tribes once notified constitute a homogeneous class, except the fact that disparate social groups designated as castes or tribes are described as scheduled, there is no homogeneity amidst them in a sociological sense. Mere clubbing of distinct castes or tribes by itself will not render them homogeneous. As long as amidst these castes or tribes, there is no uniformity of status, position, or social attainment, there can be no homogeneity. They continue to be distinct social groups or sections of the community. Each one of them constitute distinct segments deserving distinct constitutional treatments. The homogeneity, if any, compared with the non-scheduled section of the community cannot be of any consequence. The distinct constitutional treatments will always remain subject to be addressed under the Equality Charter of the Constitution, Articles 14 and 16. The constitutional treatments that the state may devise to address the concerns of one or more of the enumerated scheduled castes or tribes will always depend upon a relevant inquiry on the need and expedition required. The fact that parts of or groups within castes, race, or tribes can also be notified is an indication that the enumeration itself will be based on the connection between enumeration and the purposes of the Constitution. The question, however, as to whether such measures of advancement under Articles 15 and 16 constitute a fair spread of measures of advancement and inter se not discriminatory will be an independent inquiry entirely unconnected with Articles 341 and 342. The obligation on the part of the state to ensure fair and non-discriminatory availability of the measures of advancement will always be tested on relevant grounds. It's also expected that the state will act fairly in this regard, will not be partisan, and will not arbitrarily exclude anyone on the enumerated list from the fruits of advancement measures. The power given to the Parliament under Article 341(2) is also confined to the domain of enumeration, and the authority to include in or exclude from the list notified cannot be equated to the power of the state under the Equality Charter of Articles 14 and 16 of the Constitution of India. The Constituent Assembly debates in Article 16(4) show that the framers decidedly use the expression backward classes in plural to comprehend all social groups, including scheduled castes, which can be considered backward on certain common criteria and aspects. The 9th decision in Indira Sani has illustrated its understanding. No doubt can now be raised as to the comprehensiveness and inclusiveness of the expression. To the extent discussed above, it can be said that E.V. Chinnaya has frozen all state authority or authority of the states under Articles 14 to 16 of the Constitution. Whether it is in tune with the constitutional dynamics is a question that deserves to be answered. E.V. Chinnaya does not answer many questions raised above. It is built on the premise that all enumerated castes and tribes can and must collectively enjoy the benefits of reservation, regardless of inter-se inequalities, and that any subdivision will dilute collective identity and rob the fruits of collective emancipation. This broad statement has no demonstrable truth in empirical terms and is certainly not supported in the judgment itself. The E.V. Chinnaya holding that homogeneity of flows in the state of Kerala is open to question. I don't propose a lot of reading several paragraphs in it. I'll just point out 2 or 3 paragraphs of Justice Thomas and Justice Krishnaya in a short while. Articles 14 to 16 constitute a triumvirate of citizens' rights and state obligation. They've been conceived as equality and social justice charter, guaranteeing both right towards emancipation from social, educational, and economic backwardness, and non-discrimination in all walks of life and state transactions. The state is under a corresponding obligation to devise measures and methods, fashion policies and tools to regard, promote, and protect these rights. The enabling nature of Articles 15 and 16 are instead of duty coupled with power. Any undue limitation on both duty and power in the context of these provisions will be constitutionally suspect. The court has delineated several facets of these rights and also declared in the interplay between these rights. The equality rights in Article 14 and equal opportunity rights in 15 to 16 have mutually reinforcing facets. The evolving dimensions of these rights, in consonance with changing social and economic aspects, have been carefully crafted over a period of time, both by legislation and judicial pronouncements. The obligation of the state and the states to undertake emancipation of the deprived and weaker sections of the community, the obligation to eradicate inequalities in status and wealth, a complex obligation involving redistribution and reallocation of resources and opportunities, and equitable access to all public and social goods. Education, health, and public employment are all public goods of immense value, facilitating citizen participation in the affairs of the state on an informed and equal basis. The states will therefore always need the freedom to carry out informed experiments without being fettered by undue or disproportionate claims. There are no and cannot be any textbook answers or precedents of perennial value and relevance which can guide the state or the states as regards the roads to be traveled or measures to be taken to promote fundamental rights. The court too will bear the social dynamics in mind and be careful not to chain the state or clamp its hand while interpreting constitutional provisions. Rule of law also demands that the state is able to harmonize and balance several competing claims and interests. I'll just take a couple of paragraphs in A.N.M. Thomas.
Just give us the paragraphs, Mr. We'll have a look at them because those have been read out.
No, you.
Give us the volume and page, that's all.
A.N.M. Thomas, volume 5.
Volume 5. Which paras?
Paragraphs 53 and 54. You'll just turn to page 26. I just probably read it from the head note to give those references.
53 and 54, and then,
Justice Matthew's judgment
right,
at page 26. There are two paragraphs referred to there.
and
Paragraph 53 and 54 bracketed together.
anything more? Which other para? We need to bring, yeah, both of them.
Adam Thomas has been read to us
Read
many
at
times.
Paragraphs 53 and 54. This PDF page 53, is the PDF page, or 57? Paragraph 53.
Seven. Correct? Yes. Paragraph 53 and 54.
57, look at para 53.
And
Para
54.
53, para 54.
Yes,
Proportional equality,
that's right, formal
Formal
equality.
formal equality, proportional
Just
equality.
is. The third line, but men are not equal in all respects. The claim for equality is in fact a protest against unjust, undeserved, and unjustified inequalities. So going a little down in the same paragraph, last line, we therefore have to resort to some sort of proportionate equality in many spheres to achieve justice. Then the next paragraph, the principle of proportional equality is attained when it equals so and so. This will raise the baffling question, equal and unequal in what? The principle of proportional equality therefore involves in appeal to some criteria in terms of which differential treatment is justified.
There are various terms used in the various judgments in
Yes.
That's right.
and Adam Thomas. It has also been decided as a compensatory discrimination.
That's right. Back to. And also paragraphs 81 and 82, let me make a note of that. 81, 82, again, Justice Thomas' judgment.
82.
Yeah, 82 now.
PDF page 65.
Yes. This has already been argued, Mr. AG.
Yes.
Yes.
You made a note in your.
Then paragraph 141 of Justice Krishnaya judgment at PDF page 86.
Thank you, Mr. Attorney General. Thank you so much.
The paragraph begins at the basic question.
Yes, we'll have a look at it, Mr. Attorney. Thank you so much.
That's right.
Anybody else now who would like to, Mr. Solicitor is here?
One in Chinaya, paragraph 113 of Justice Sinha judgment, just kindly look at that.
Yes.
This is PDF page volume 5, page 815.
Sinha J, paragraph,
113.
page,
PDF page 819.
PDF page 8. We'll have a look at it, Mr. Attorney. We'll have a
PDF page. Just look at the paragraph. The power of the state legislature to decide as regards grant or benefit of reservation so and so is not in dispute.
Yes.
Furthermore, not in dispute that if such a decision is made, the state can also lay down a legislative policy as regards the extent of reservation to be made for different members of the backward class, including scheduled caste. But it cannot take away the state benefit on the premise that one or the other group among members of so and so has advanced, and thus is not entitled to the entire benefit reservation. That begs the question.
Thank you, Mr.
That's right.
Thank you, Mr.
Please,
Mr. Solicitor.
I will not take more than 10 minutes, my lord.
Solicitor is also there.
I'll bear in mind the distinction between a person, my lord, who has something to say and a person who has to say something. My lord, it is very ably argued by, my lord, all my predecessors, my lord, and especially the learned advocate general. My lord, please take my volume 1I. It's a 15-page note. I'm not going to read the entire.
It has come on the screen, yes. It has
It
not,
is there, my lord. Your lordship would find it at one.
it is
It's here.
here on
I'm
the
sorry.
screen, yes.
My lord, what I have done is, my lord, I have given a history which I am again not going to place before your lordships
Yes.
as to how this developed. But the most relevant part is, slowly and gradually, your lordships on the judicial side has started taking note of the fact that there needs to be some rationing.
Right.
At the outset, I say, my lord, on behalf of the central government, lord, it is not my submission about the reservation. Reservation as a policy, the central government is committed to. My written submissions, my lord, are only confined to the question referred whether there can be a sub-classification or not.
Right.
And sub-classification as a concept was bothering your lordships, my lord, and there are some judgments which reflect that. Lord, please see page, Lord, 1. It starts with, my lords, the Chief Justice recently said, my lord, Champakam, my lord, I am not going into that, my lord. Thereafter comes Balaji. Balaji says that this is an exception to 15 and 16(1), and thereafter, which is changed in N.M. Thomas, my lord, which says that it's not an exception, it's an equality thing. Lord, thereafter, your lordships may kindly come to M. Nagaraj, my lord, which is at page 3. In M. Nagaraj, in my respectful submission, this question, my lord, started bothering your lordships, whether there needs to be some rationing so that the real beneficiary gets the benefit. Lord, please come to para 10. Thereafter, the judgment in Nagaraj was referred to a 5-judge bench to examine the correctness on 2 counts. Lord, first, your lordships can skip B. Second, being whether the concept of creamy layer can be made applicable to the scheduled caste and scheduled tribes. So those who are taking the majority of the benefits and depriving the more backward, should that concept come in or not, my lord? Lord, thereafter came, my lord, Jarnail Singh. Please come to page 12. And I have quoted, my lord, the relevant part, para 12, my lord, I'm sorry, page 4, para 12. The judgment in Jarnail Singh refers to the broader object of amelioration of backward classes and clarifies that this cannot be achieved if only the creamy layer within that class bag all coveted jobs in the public sector and perpetuate themselves, leaving the rest of the class as backward as they always were. Lord, thereafter comes, my lord Jason, Lord, recent judgment, my lord, Maratha reservation judgment, my lord, where, my lord, your lordships have said that, have, my lord, reiterated that constitution is always an evolving document, and therefore we will have to answer to the needs of the hour. My lord, I am just placing it for your lordships consideration. I am not reading it, my lord, because it gives a broader perspective how your lordships would view a constitutional provision which is, my lord, for the betterment of the backward classes. Lord, then, my lord, I have, though that's not the question referred, But just by way of an abundant caution, I have, my lord, at page 5, given finality of Article 341, which remain unaffected, my lord. But even if your lordships were to take the view that subclassification is a permissible mode, my lord, that also would be as per the same constitutional route as prescribed. The state would recommend to the president, then thereafter it will go to the parliament, and parliament will decide whether to put it in the schedule or not, my lord. That's not the question, but by way of abundant caution, my lord, I have placed it for your lordship.
According to you, sub-classification will have to be done only by the parliament.
Yes, ma'am. No, my lord,
No.
it's
It can be done even by this,
identification by the state.
by parliament.
Yes, my lord.
And-
What is happening
and
now?
Implementation by the states.
By the state again. What happens, my lord, now? One caste is identified as a scheduled caste. It's only identification by the state. It comes to the President of India, then goes to the Parliament. And thereafter, after parliamentary legislation, that caste is notified for that state as a scheduled caste. And thereafter implemented by that state. So, my lord, that is not the question, but by way of abundant caution, my lord, I have quoted, my lord, Basav Lingappa, that 341 is absolute, my lord, and state of Maharashtra versus Milind. Lord, I'm not reading it because that's not the question my lords are, my lord, considering. But, my lord, now kindly come to page 11, my lords. Ashok Kumar Thakur, my lord, this is 2008, where almost, my lord, your lordships were bordering on this issue, which your lordships are, my lord, considering now. Para 6 and 9. Reservation is one of the many tools that are used to preserve and promote the essence of equality, so that disadvantaged groups can be brought to the forefront of civil life. It is also the duty of the state to promote positive measures to remove barriers of inequality and enable diverse communities to enjoy the freedoms and share the benefits guaranteed. Lord, thereafter, please come to, my lord, M. Nagaraj, page, para 23, my lord, page 11. Para 48 is relevant, my lord, at the foot of that page. It is the equality in fact which has to be decided looking at the ground reality. Balancing comes in where the question concerns the extent of reservation. If the extent of reservation goes beyond cutoff point, then it results in reverse discrimination. Anti-discrimination legislation has a tendency of pushing towards de facto reservation. Therefore, a numerical benchmark is the surest immunity, etc., etc. Lord, please then come to N.M. Thomas. Lord, this is quoted in Jarnail Singh, para 124. A word of sociological caution. In light of the experience, here and elsewhere, the danger of reservation, it seems to me, is threefold. I'm not arguing against the reservation. I'm just not flagging the sub-classification issue, because sometimes we are likely to be misunderstood intentionally or unintentionally. Its benefits, by and large, are snatched away by the top creamy layer of backward caste or class, thus keeping the weakest among the weak, always weak, and leaving the fortune layers to consume the whole cake. Yes. Your lordships, my lord, flagged this for the first time. Justice, my lord, Justice Krishna Iyer, my lord, flagged it, which is now followed by the recent judgment in, my lord, Chelbro Leela Prasad Rao versus State of Andhra Pradesh. My lords would find it at page 13. Para 165, your lordship gets for in our, my lords get them. Yes. In our opinion, it was rightly urged by Dr. Rajiv Dhawan that the government is required to revise the lists. It can be done presently without disturbing the percentage of reservation, so that benefits trickle down to the needy and are not usurped by those classes who have come up after obtaining the benefit for the last 70 years or after their inclusion in the list. Lord, thereafter comes, Lord, not in point of time, Lord, in my chronology, R. Chitralekha. This interpretation will carry out the intention of the Constitution expressed in the aforesaid articles. It helps the really backward classes instead of promoting the interest of individuals or groups who they belong to a particular caste a majority whereof is socially and educationally backward, really belong to a class which is socially and educationally advanced. To illustrate, take a caste in a state which is numerically the largest therein. It may be that though a majority of the people in the caste are socially and educationally backward, an effective minority may be socially and educationally far more advanced than another small subcaste, the total number of which is far less than the minority. If we interpret the expression classes or castes, the object of the constitution will be frustrated and the people who do not deserve any advantageous aid may get it to the exclusion of those who really deserve. This anomaly will not arise if without equating caste with caste, etc., etc. My lord. Your lordships, my lord, then come to, my lord, it was, this Vasant Kumar was read by, my lord, the learned AG. My lord, I am not therefore repeating. My lord, on page 15, I have given, my lord, my propositions, my lord. There are four propositions. I'm not, my lord, going to read. I am just placing it for your lordship's consideration. This is again, my lord, at the cost of repetition, only to answer the constitutional question whether subclassification is constitutionally permissible, but not against reservation in any form.
Thank you, Mr.
But Mr. Agarwal is appearing for Chandigarh administration, but he may be given some time. Maybe after the.
Should we hear Mr. Napade, right after lunch?
I will start after lunch.
After lunch, because we're almost at the stroke of one.
Very well. I'll be
We
very,
had actually planned to complete this side by one, so we'll.
I'm also,
That's eating into the time of the other.
I'm also there, minutes, I may take 5 minutes, minutes. I'm also there.
For Haryana have to be submitted. Only 5 seconds.
It's going to be 10 minutes.
After Tamil Nadu.
We'll hear Mr. Napade right now.
At 2 o'clock we start.
Grateful to all.